Hey creator, do you have a website? I know that I do. And if you do have a website, then you need to know about the California Consumer Privacy Act. It goes into effect on January 1st, 2020, and if you violate the act, you could be liable for hundreds of thousands of dollars in fines and penalties. You could lose your YouTube account and your other social media accounts. You could be left in financial ruin. But the big question out there is, does the CCPA even apply to you, the social media creator? In this video, I'm going to answer that question, and I'm going to give you some concrete steps and a legal document that'll help you protect yourself against the CCPA. All right, let's hit this. Hey creator, I'm Ian Corzine, your social media lawyer, and on this channel, I give you the law you need to protect your social media. Today, we're talking about the California Consumer Privacy Act, which goes into effect on January 1st, 2020. And it is a big deal because if you violate this privacy law, you could be liable for hundreds of thousands of dollars in fines. It could shut down your business, shut down your YouTube channel. But the key question, and the one we're going to talk about mostly today, is whether or not the CCPA actually applies to you, the social media creator. But before we get to that, let's talk about the background of the CCPA. What is the CCPA? Well, the CCPA is actually like 18 pages of law, so I'm going to do my best to break it down for you. But the California Consumer Privacy Act was a law that was passed in 2018. And the law's main purpose is to protect California residents and their personal information online. It has various rules about data collection and how and when this information can be shared and sold. You might say, hey, I'm not a California resident. This CCPA doesn't apply to me. And I would say, so? Do you have any viewers or listeners on your social media content that live in California? Only one? Because if you do, then the CCPA applies to you. The CCPA was passed because the government believes that people have the right to control their personal information online, and they want to stop businesses from taking this personal information without the permission of the people and then using it for a monetary purpose. Before the CCPA was passed, there was really no law that helped people control their personal information online and provided penalties for businesses that took it without their permission. As a result, there were a lot of financial crimes committed. There was identity theft, there was online harassment, there was financial fraud. I mean, think about the Cambridge Analytica case. That was where Facebook allowed a researcher to come in and access the data of 87 million people. The researcher said he was using this data for academic purposes, but in actuality, he sold it to Cambridge Analytica. Cambridge took the information to bribe politicians, to blackmail politicians in the 2016 race. Now, this data for 87 million people was used for a bad purpose, but no one was sued, no one went to jail. The purpose of the CCPA is to prevent this from ever happening again. So the CCPA gives people the right to know what personal information a business takes, how they take it, where they take it, why they take it, and the requirement for businesses under the CCPA is they have to disclose all the types of personal information they collect from people online. They have to allow these people to access the information, to have it deleted, to opt out of the selling of their personal information, and it prevents businesses from discriminating against people who say, I don't want my personal information sold, but I still want to use the services of this business. And the key point about the CCPA is that it's liberally construed. And basically, that's just legal jargon for understanding that if there is some question about how the law applies, then the business, meaning you, doesn't get the benefit of the doubt. The consumer gets the benefit of the doubt. I think the CCPA is a good thing. I mean, it is great to allow people to control their personal information online. I don't even know how much personal information I'm transmitting when I'm using Facebook or Google or Amazon. And so it's really good that I can access it. I can delete it if I want to. I can tell them, listen, don't use my personal information. Don't sell it. So this is a really laudable goal, and it applies to businesses. But the biggest question out there is whether or not the CCPA applies to you, the social media creator. And the answer to that question is yes. If you have any viewers of your social media who live in California, only one even, then it does apply to you if you have a website that requests personal information from people, like a name or an email address, anything. Even if your website doesn't directly request the personal information of people that come to it, then you could be subject to the CCPA if your website uses web cookies. I didn't know whether or not my website, iancorzine.com, used web cookies, so I did a search and I found this website called cookieserve.com. I'll put a link in the description. You go to this website, you enter in your website URL, and then it will tell you whether or not there are cookies that work on your website. And check this out. When I did it, I saw dozens and dozens of cookies that are attached to my website collecting personal information. I was totally surprised by this because when I was making my website, I had no idea that somehow cookies were being incorporated in it from YouTube and Amazon and other big websites. Go to cookieserve.com and check for yourself. It's free. I had no idea the depth of information that it has. Now we get to the key point about whether or not you have to comply with the CCPA. And that is, we know that if you have a California viewer of your social media, we know if you have a website, but the big thing is that your website has to receive at least 137 pieces of personal information per day. The actual law in the statute says 50,000 per year. Your website has to receive, share, somehow interact with. If your website does do 137 touches of personal information, then you will be subject to the CCPA. So yeah, it affects a lot of us, especially people that do a lot of business on their website. Bottom line, creator, if you have a website to support your social media accounts, then you need to be concerned about the CCPA. These privacy laws are not going away, and they're getting even more stringent every single day. If you go online, you'll see a lot of articles that say that the CCPA only applies to larger online businesses. And there are a couple qualifications that put those kind of businesses under the CCPA. One of them is a business that makes more than $25 million a year in gross revenue. Another one is a business that derives more than 50% or more of its income from trading, sharing the personal information of others. But the really, really important other part is that the law also applies to businesses that touch the personal information of 50,000 or more consumers during a given year. And listen, if you have a website that's really, really pumping out the business, and I hope all of you do, then you need to be concerned because you will be subject to the CCPA. And the CCPA also applies to social media accounts like your YouTube account, like your Instagram or Facebook account. I'm gonna get more into that in a few minutes about that. But first, I wanna talk about the penalties if you don't comply with the CCPA. Even if you say to me, Ian, the CCPA does not apply to me, I still say you should be concerned because a lot of states are passing similar laws to that of California, and the federal government has actually introduced a bill called the Consumer Online Privacy Rights Act that may be passed in the next couple of years, and it has similar requirements as the CCPA. And additionally, you have to realize that just because the California law has the 50,000 touches of personal information requirement or the 25 million gross revenue requirement, other states, the federal government could lower those thresholds. So it may be that there's only 10,000 touches of personal information needed to touch these type of privacy laws. So you really should get prepared right now, and if you don't, you're gonna face some big penalties. You could be sitting there saying, Ian, are there a lot of things I need to do if my website is subject to the CCPA? Yes, it reminds me of that Online Protection Act that California passed in 2003, which required all these disclosures on your website concerning what information you collect, how it can be changed, notice about changes to the privacy policy. So the CCPA has some changes that you need to implement on your website. I'm gonna get to those in a few minutes, but first I do wanna talk about the penalties. What happens if you don't have the money, if you can't comply with the CCPA? What is gonna happen? I hate to say this, but if you can't comply with the CCPA, then you're gonna get sued. There are two different groups of people that could bring a civil action against you for violations of the CCPA. The first are consumers, actual people in California who are affected by a breach of their personal information can sue you. Now they can only sue you once they give you 30 days notice of this breach and what happened. If you can comply, if you can cure this breach, then you can possibly save yourself from being sued. But if you can't, or if there's no way to cure it, then they can bring a civil action against you and recover damages of between $100 to $750 per violation, per privacy violation. The second group of people that can sue you if you violate the CCPA is the Attorney General of California. He can bring an action after the 30-day notice period and recover $2,500 per privacy violation if it's unintentional, or $7,500 per violation if he has evidence that you intentionally violated the CCPA. So if you violate the CCPA, you can't comply, it could result in your financial ruin. You could lose your YouTube channel and all your social media accounts and your online business if you don't comply with the CCPA. So now you know what the CCPA is. You know that if you have a website that does good business, you could be subject to the CCPA. You also know that the CCPA applies to your social media accounts like YouTube, Facebook, and Instagram. Thankfully, all the big companies like Google and Facebook and Amazon have done all the hard work and they are compliant with the CCPA. So you don't need to do anything else if you have these social media accounts and you don't have a website. But if you have a website, you've got to be concerned. You understand now those stiff penalties that you may face if you do not comply with the CCPA. So there's a lot in front of you about complying, following the CCPA law, and it's a little scary. There are litigators out there, especially California lawyers, that want to bring suits and they're sue happy. So you've got to be concerned. So the next question that you probably have is, what do I do if I have a website, I have California customers, and I want to be CPA compliant? And I have a way out for you. I've read the whole CCPA and the regulations. These are additional laws that supplement the actual law, and also article after article online, and watch videos. And so I have a path to compliance for the CCPA. I want to answer the question for you. What does a social media creator do to comply with the CCPA? Well, there's 4 things you can do to comply with the CCPA. The first thing is you need to update your privacy policy on your website. You need to disclose what personal information you collect, how you get it, why you collect it, what purposes are you using that information for. And there's some detailed requirements about notice and disclosure in the law. I encourage you to actually read this law. I know it's a really long piece of legislation, but read it and also consult your local social media lawyer for how it actually applies to your website. The second thing you need to do is have good security software and good security protocols or rules for how you handle the personal information of your customers. It's really important because the real focus of this law is it wants to protect against breaches of personal information from people that are using your website. So you have to have some rules for how this information is protected. You have to have good security software to prevent against hacking of this information. And you really need to safeguard the personal information of your customers. And the third thing you need to do is really important, and that is on your website, you need to create links that allow people to request access to their personal information, that allow people to request deletion of their personal information, to allow people to opt out of the selling of your personal information, and you have to have an opt-in link that allows kids 13 to 16 to be able to opt in to the selling or the sharing of their personal information. You have to create a system by which the people can communicate to you through your website and actually get these purposes accomplished: deletion, access, opting out of the selling the personal information. What we're seeing out there are a lot of companies who are complying with CCPA have do not sell my personal information, do not sell my info buttons on their websites. You click that, it goes to another page which has a lot of CCPA disclosures, and it allows these people who are on the website to make the various requests I just discussed to the website owner. The other part of the CCPA that you really need to pay attention to is that you need to take records of the people that made the various requests to your website. You have to have written records that you can transfer to whoever's investigating your non-compliance of the CCPA. And the final thing you need are new contract clauses in vendor agreements. So let's say you're gonna have an event in Los Angeles somewhere, and so you request the personal information of people that come to your website, and then you want to invite them to this event, but you use a vendor to do that, a hotel or a catering company or something like that. Then you need to have in the contract the various requirements and disclosure requirements for the CCPA, and you need to have this one term that says, listen, this third-party vendor, as your representative, agrees to comply with the CCPA. Now, I know a lot of these requirements are detailed and it's hard to remember, and so what I did is I put together a CCPA compliance checklist. You can use this checklist to make sure that your website and your social media site, your online businesses, are CCPA compliant. To be able to get this free checklist, you can text CCPA to the number you see on the screen. That's my cell phone, and I'll respond with a link so you can get this checklist. And if you need a new CCPA compliant privacy policy for your website, or you need an opt-out template, or you need new language for your vendor contracts, feel free to contact me and set up an online consult at iancorzine.com. Creator, I know it's easy to say that the CCPA doesn't apply to me, but I encourage you to follow the rules of the CCPA because it's not going away. The thresholds for security and the holding of personal information online are not going away. More and more states are passing similar laws. And as I said, the federal government has a bill right now that has similarly worded language to the CCPA. So we're all gonna have to follow these privacy rules at some point. Why not start now? Even if later on you have to make little tweaks to comply with Florida law or the federal law, it's better to do little tweaks later on in time than have to totally revamp your website after, let's say, you get 100,000 visits and 100,000 receipts of personal information per year. And the penalty for violating the CCPA is just too great. You do not want to be sued in a class action for hundreds of thousands of dollars and potentially lose your business, lose all your social media accounts, your YouTube channel, your Facebook account. You don't want to do that. It's better to be proactive and follow the CCPA this time than pay for it later. So download my checklist by texting CCPA to my cell phone number that you see on the screen and follow that checklist, and also consult with your local social media lawyer. Now let's move on to discussing how you protect your YouTube channel and your other social media accounts from this new CCPA law. Have you heard about this law? If you want to learn more, you should watch right here. And as always, as you watch, I'll be here. I'll be ready to answer your questions at iancorzine.com.